Here's something nobody on mainstream television is going to tell you straight. The most powerful economic weapon in modern American history, a weapon that collected over $166 billion in a single year, was just struck down by the United States Supreme Court. Gone. Just like that. And yet, within weeks, the same administration that lost that battle is already promising to have those exact same tariffs back in place by July. Let that sink in for a second. The highest court in the land rules your policy is unconstitutional. And your response is to say, essentially, watch us do it anyway. Now, you might be thinking, is this legal? Is this a power grab? Is this economic genius or economic madness? And more importantly, what does any of this actually mean for your grocery bill, your job, the price of a car, or the future of global trade? Because here's the truth. The tariff war that everyone thinks is over is just getting started. And the next chapter is going to be far more complicated and far more consequential than anything we've seen so far. And if the news you've been watching isn't breaking this down for you, that's exactly why World Brief exists. We cut through the noise. We follow the story past the headline. Hit subscribe right now so you never miss what the rest of the world already knows. Because this story is moving fast and you cannot afford to be behind on it. Let's go back to the beginning of this story. Because to understand where we are right now, you need to understand the legal foundation that collapsed underneath the Trump administration and why it collapsed. For the past year, the Trump White House has been waging an aggressive tariff campaign, essentially placing heavy taxes on imported goods coming into the United States. The stated goal: force other countries to play fair on trade, bring manufacturing jobs back to American soil, reduce a massive decades-old trade deficit. And the legal authority they use to do all of this, something called IEEPA, the International Emergency Economic Powers Act. Now, IEEPA is a law that's been around since 1977. It gives the president extraordinary powers to regulate international commerce during a national emergency. In the past, it's been used to freeze assets, block financial transactions, sanction foreign governments. It's a powerful tool, but it's never quite been used the way the Trump administration used it. The Trump White House essentially declared that America's trade deficits, the gap between how much we import versus how much we export, constituted a national emergency. And under that emergency declaration, they imposed sweeping tariffs across the board, not just on China, not just on one or two adversaries, on everyone, trading partners, allies, and rivals alike. At its peak, this tariff regime was generating staggering revenue. By mid-December alone, more than $133 billion had flowed in from IEEPA tariff duties. By early March of 2026, that number had grown to around $166 billion. $166 billion. And then, in February of this year, the Supreme Court of the United States said no. The court ruled that IEEPA simply does not authorize tariffs. The president cannot use that emergency economic law as a blanket justification to tax imports at will. It was a devastating ruling, a direct, unambiguous blow to the central economic strategy of the Trump administration. But here's where it gets interesting, and this is the part of the story that most people aren't paying close enough attention to. When a presidential administration loses a major case at the Supreme Court, the standard playbook is usually one of two things: either accept the defeat and move on, or spend years trying to get the right case back in front of the right court. The Trump administration chose a third option. Within weeks of the ruling, they began systematically rebuilding their entire tariff strategy from scratch, using entirely different legal authorities, authorities that the Supreme Court hadn't touched, authorities that were written into law decades ago and had been mostly dormant since then. The primary tool? Section 301 of the Trade Act of 1974. Now, Section 301 is a very different animal from IEEPA. While IEEP was designed as an emergency power for extraordinary moments, Section 301 was specifically designed as a trade enforcement mechanism. It allows the president and the U.S. Trade Representative, a senior official whose job it is to manage America's trade relationships, to investigate foreign countries that engage in unfair or discriminatory trade practices against American businesses. And if those practices are confirmed, the United States can impose retaliatory tariffs. This is the mechanism that Treasury Secretary Scott Bessent was referring to when he spoke at a Wall Street Journal event just this week. We had a setback at the Supreme Court in terms of the tariff policy, Bessent said, but we will be implementing or conducting Section 301 studies. So the tariffs could be back in place at the previous level by the beginning of July. That is an extraordinarily aggressive timeline. And it tells you everything you need to know about how urgently this administration wants to restore its economic leverage. But here's the catch, and this is critically important. Section 301 is not a switch you just flip. Unlike EPA, which gave the president the ability to act with very little process, Section 301 requires formal investigations. It requires a period of public notice and comment. There are legal procedures that must be followed before enforcement can begin, which means the administration isn't just launching one or two investigations. According to a detailed report from Alan W.M. Wolf, a senior fellow at the Peterson Institute for International Economics, the Trump administration has initiated over 75 Section 301 investigations since the Supreme Court's ruling. 75. That number is staggering. To put it in perspective, the average annual number of Section 301 investigations over the past 5 decades is a tiny fraction of that. The Trump administration has blown past 5 decades of historical precedent in the span of a few weeks. What that tells you is this: they are not planning to use Section 301 as a narrow, targeted weapon. They are using it as a bulldozer. They are trying to build a legal case for reimposing tariffs on virtually every major trading partner at the same time. And they want to do it fast enough to have everything locked in before the summer. But wait, because Section 301 isn't the only lever being pulled here. At the same time the administration was filing dozens of Section 301 investigations, President Trump also announced a new set of 10% global tariffs, this time using a completely different legal authority, Section 122 of the same Trade Act of 1974. Section 122 is a provision that allows a president to unilaterally impose import fees of up to 15% on U.S. trading partners for a period of 150 days in order to address what the law calls large and serious balance of payments deficits, or situations that risk immediately weakening the value of the dollar. In other words, if America is spending far more buying things from the world than the world is buying from America, and if that imbalance is threatening the stability of the dollar, the president has emergency authority to impose temporary tariffs without going through the same lengthy process required by Section 301. Now, the White House is arguing that America's massive trade deficit fits squarely within this description, and predictably that argument has already landed in court. 24 state attorneys general filed a lawsuit arguing that the Section 122 tariffs were an illegal attempt to sidestep the Supreme Court's ruling. The case went before the U.S. Court of International Trade in Manhattan, a specialized federal court that handles trade disputes. At the hearing, lawyers for the challengers argued that if the court allowed the administration's broad reading of Section 122 to stand, it would essentially turn this provision into an all-purpose trade weapon, something that could be deployed any time against any country for any reason the president deemed to be a trade imbalance. Upholding the administration's broader view of the law, the challengers said, would effectively turn Section 122 into an all-purpose trade weapon. The Department of Justice pushed back. Their lawyer, Brett Shumate, argued that Congress had always intended to give presidents wide discretion when it comes to assessing economic conditions. A trade deficit was a large driver of a balance of payments deficit in 1974, as it is today, Shumate told the court. We're not on the gold standard anymore. We don't have a fixed currency, but we can still have balance of payment problems. The case is still being argued. The outcome is uncertain. But what's crystal clear is that the Trump administration is fighting on multiple legal fronts simultaneously to preserve its ability to tax imports. And it is doing so with a speed and intensity that is genuinely unprecedented in the modern history of U.S. trade policy. Now let's zoom out, because at this point you might be thinking, okay, this is an interesting American legal drama, but why does it matter to me if I'm not in the United States? Why does it matter to the rest of the world? The answer is because tariffs are not just an American story. They never were. When the United States, the world's largest economy, starts taxing imports at scale, it doesn't just affect the countries sending goods into America. It sets off a cascade of reactions across the entire global trading system. Think about what happened when the initial IEEPA tariffs were imposed. Countries like China, Canada, Mexico, the European Union, they didn't just sit back and absorb the blow. They retaliated. They imposed their own tariffs on American goods. American farmers suddenly found their soybeans, their pork, their corn facing tariff barriers and market markets they'd been selling into for decades. American manufacturers found the steel and aluminum they needed to build things was getting more expensive because other countries were restricting access to raw materials. Trade wars are not one-sided. They are by nature two-sided, and very often they spiral into something far bigger and far messier than anyone originally intended. And now, with the administration pivoting to Section 301 and Section 122 to rebuild its tariff architecture, other countries are watching very carefully. China, in particular, is watching. Because Section 301 investigations have historically been aimed most aggressively at China, at things like Chinese government subsidies for domestic industries, intellectual property theft, forced technology transfers as a condition of doing business in China. These are real grievances. American businesses have been raising them for years. And under Section 301, they become the legal basis for tariffs that could be just as sweeping as anything imposed under IEEPA. But China is not going to simply absorb another round of tariffs without responding. And neither are many of America's European allies who have already been through one round of tariff tensions and do not want another. The global question right now is whether this second wave of tariff policy, built on Section 301 and Section 122 rather than IEEPA, will trigger a new round of trade retaliation around the world. And if it does, the consequences for global supply chains, inflation, interest rates, and economic growth will be felt everywhere, not just in Washington, not just on Wall Street, in every country that trades with the United States, which is essentially every country on Earth. Here's the thing that gets lost in the legal back and forth, the arguments about IEEPA and Section 301 and balance of payments deficits. This is actually a debate about two completely different visions of how the global economy should work. On one side, you have the free trade consensus, the idea that the world is better off when goods and services flow as freely as possible across borders, when every country specializes in what it does best, when consumers everywhere get access to the widest possible range of products at the lowest possible prices. This was the dominant framework for most of the post-World War II era. It drove the creation of the World Trade Organization. It underpinned trade agreements from NAFTA to the Trans-Pacific Partnership to dozens of bilateral deals. And by many measures, it worked. Global poverty fell dramatically over the past 50 years, and living standards rose in country after country that opened its doors to international trade. On the other side, you have the economic nationalist view, the idea that free trade, however efficient it may be in theory, has created dangerous vulnerabilities in practice, that the United States hollowed out its manufacturing base, that entire communities built around steel mills and textile factories and electronics assembly lines were devastated when those jobs moved overseas, that the global supply chain disruptions of the COVID-19 pandemic exposed just how fragile it is for a country to depend on foreign suppliers, sometimes adversarial foreign suppliers, for critical goods ranging from semiconductors to pharmaceuticals to basic industrial materials. And this isn't a left-right debate in the traditional sense. When you look at the polling, you find that skepticism about free trade and support for some version of tariff protection cuts across party lines. There are working-class communities in the industrial heartland that support these tariffs and have been waiting for decades for someone to fight for them. And there are economists and business leaders in financial institutions from across the political spectrum who argue that tariffs raise prices, distort markets, and ultimately make everyone poorer. Both of these arguments have real substance. And that's why this legal battle, as technical as it sounds when you're talking about Section 301 studies and balance of payments deficits, is actually one of the most consequential ideological fights happening in the world right now, because the outcome will help determine not just American trade policy, but the rules of the global trading system for the next generation. So where does this go from here? There are several things to watch very closely in the coming weeks and months. The first is the courts. The Section 122 tariffs are already being challenged, and that case is moving quickly. How the Court of International Trade rules will be a major signal about how much legal running room the administration actually has. If the court sides with the challengers and strikes down Section 122, the administration loses another major tool. If the court upholds Section 122, it gives the White House significant new authority to act, and you can expect that authority to be used aggressively. The second thing to watch is the Section 301 investigations. With over 75 investigations now underway, the timeline Besant described, tariffs back in place at previous levels by the start of July, is ambitious but not impossible. These investigations move fast when the political will is there, and right now, the political will in Washington is as strong as it has ever been on this issue. The third thing to watch is the international reaction. Every country that trades with the United States is currently calculating its response to this second wave of tariff pressure. Some will negotiate, sitting down with American trade representatives and offering concessions in exchange for tariff relief. Some will retaliate, imposing their own tariffs on American goods in response, and some will try to do both at the same time. The diplomatic conversations happening behind closed doors in Beijing, Brussels, Ottawa, and Tokyo right now will shape the contours of global trade for years to come. And the fourth thing to watch, perhaps the most important, is the domestic political reaction. President Trump has framed tariffs as life or death for the U.S. economy. That is extraordinarily strong language. It signals that this is not a policy the administration is willing to walk away from, no matter what the courts say. If the courts keep striking down one legal mechanism after another, the question becomes, how far is the administration willing to go to keep these tariffs in place? Are there executive authorities that haven't been tested yet? Are there actions that could be taken unilaterally without congressional approval that go beyond what we've seen so far? These are not hypothetical questions. They are the questions that Washington's trade lawyers and constitutional scholars are already asking, and they don't have clean answers yet. Let's bring this home because I want to make sure we're clear on what's actually at stake here. This is not just about the United States. This is about the architecture of global trade, a system that was built painstakingly over the better part of a century, a system that has its flaws, yes, a system that has left some people behind, absolutely, but also a system that has connected billions of people to global markets, created enormous wealth across the world, and, at its best, helped turn former adversaries into trading partners. That architecture is under real stress right now, and the legal battles playing out in American courtrooms are not just abstract legal dramas. They are, in very concrete terms, battles over who gets to decide the rules of global commerce. The president, the Congress, the courts, international agreements, or something else entirely? When the Supreme Court struck down IEEPA tariffs, it was saying there are limits, there are rules. The president cannot simply declare an emergency and reshape the global trading system by executive fiat. When the Trump administration responded by invoking Section 301 and Section 122, it was saying, we will find another way. The emergency is real. The need is real. And we are going to use every legal authority available to us to address it. Both of those positions have legitimate legal and political arguments behind them, and the tension between them, between executive power and judicial limits, between economic nationalism and global integration, is going to define a major chapter of the next decade, not just in America, but in every country that watches what Washington does and adjusts its own policies accordingly. That's the real story here, not just the tariffs themselves, not just the legal mechanisms. But the deeper question, in a world where every country is looking out for its own economic interests, how do you build and maintain a global trading system that actually works? And who gets to make the rules? We don't have a final answer to that question today. We may not have one for years, but you now understand the fight better than 99% of the people watching television news tonight. And that is exactly what World Brief is here for. Not to tell you what to think, not to pick a side in a political argument, but to make sure that when the world makes a major move, when a court ruling ripples through the global economy, when a policy shift in Washington reshapes supply chains across 5 continents, when a story that sounds like a dry legal dispute is actually about your cost of living and the future of your country's place in the world, you are not left behind. You understand it. You can talk about it. You can see through the noise. If this video helped you see the bigger picture, hit the like button right now. It takes 1 second and it tells us that you want more of this kind of deep, honest breakdown. Subscribe if you haven't already and turn on your notifications because this story is moving fast and our next video is going to track exactly what happens when those Section 301 investigations start producing results. Drop a comment below and tell me, do you think the tariffs should come back? Do you think free trade is broken? Or do you think tariffs make things worse? I read every single comment, and the best ones shape what we cover next. Share this video with one person who you think deserves to understand what's actually happening in the world. This is World Brief. We'll see you in the next one.